Welcome to Breaking Bulletin, where headlines are just the beginning. Facts are explored with context, history, and bold questions. If you're passionate about law, politics, identity, and the forces shaping our society, you're in the right place. Please take a moment to like, share, and subscribe to the channel. Your support helps us deliver deep and meaningful stories that matter. Today's story comes from the United Kingdom, and it's about a legal ruling that will shape the meaning of womanhood, identity, and civil rights for years to come. The UK Supreme Court has ruled that in the eyes of the law, the word woman means a person who is biologically female, not someone who has transitioned, not someone with a gender recognition certificate, but someone who was born female. This decision is being called a victory for gender-critical campaigners, and a devastating loss for many in the transgender community. So what does this really mean? Why does this matter? What is the role of the law in defining something so deeply personal and political? And what will the consequences be? Let's explore the full story. In December 2023, the United Kingdom's highest court issued a landmark ruling. It addressed a complex question at the intersection of law, gender, and identity. What does the term woman mean in the Equality Act 2010? Does it refer to a person's biological sex, or to their lived and recognized gender? The UK Supreme Court ruled unanimously. 5 judges agreed. Under the Equality Act, the word woman refers only to a biological female, not a transgender woman, not someone with a gender recognition certificate, only a person born female. This ruling overturned 2 decades of legal understanding. For years, people with gender recognition certificates were recognized under UK law as their acquired gender. They could change their birth certificates, and they could legally marry as that gender. They could use services intended for that gender. But this new ruling draws a hard line. It separates legal gender recognition from sex-based legal protections. The Equality Act lists sex as a protected characteristic. It allows for single-sex spaces, such as women's shelters, changing rooms, and hospital wards. It also governs public appointments, such as positions on boards reserved for women. The court ruled that these provisions were written to protect biological women, and that interpreting them differently would make those protections incoherent, the court said. If sex could mean something that changes with a certificate, then the protected category of woman would include people born male. This would undermine the entire framework of sex-based legal rights. Deputy President of the court, Lord Hodge, gave a verbal summary. He said interpreting woman to include transgender women would create legal uncertainty. It would confuse organizations and policymakers, and it would lead to what he called heterogeneous groupings, a mix of biological males and biological females, which he argued would defeat the purpose of sex-based protections in the first place. To understand the weight of the Supreme Court's decision, we need to look back. In 2004, the UK Parliament passed the Gender Recognition Act. This law allowed transgender people to obtain a gender recognition certificate, or GRC. With this certificate, their legal sex could be changed on documents like birth certificates and passports. It was hailed as a major step forward for transgender rights in the UK. It followed a ruling by the European Court of Human Rights, which held that the UK had failed to protect the private life of trans individuals. The Gender Recognition Act was passed to fix that failure. It was one of the first laws in Europe to allow legal gender recognition through a formal process. Fast forward to 2010, the Equality Act was passed. It is one of the most important pieces of civil rights legislation in the UK. It protects people from discrimination based on characteristics like race, religion, disability, sexual orientation, and sex. It also added gender reassignment as a protected characteristic. This meant that people undergoing gender transition were protected from discrimination and harassment. But the law also allowed for single-sex spaces and services. Hospitals could have female-only wards. Shelters could provide beds for women only, and public boards could be reserved for women to ensure equal representation. For over a decade, a question lingered. What does woman mean in these cases? Does it include transgender women, or only biological females? This was the legal tension that eventually reached the Supreme Court. A gender-critical group in Scotland called for Women Scotland challenged the Scottish government. They argued that allowing trans women with GRCS to sit on public boards reserved for women violated the Equality Act. They said it blurred the line between sex and gender, and they won. The court's ruling was celebrated by gender-critical groups. They argue that biology matters. That laws meant to protect women from historical discrimination should not include people born male. They say this decision preserves women-only spaces, that it ensures privacy, dignity, and fairness in places like sports, prisons, and medical settings. One of the most visible groups in this movement is Sex Matters, co-founded by Maya Forstater. She said the ruling was correct and necessary. She applauded the court for recognizing that the word woman has meaning rooted in biology. For Women Scotland, supported financially by author J.K. Rowling, also welcomed the judgment. They said it protects the integrity of the Equality Act. They argue it does not erase the rights of trans people, but clarifies boundaries that matter. But for many in the transgender community, the ruling was a heartbreak. Scottish Trans, a major advocacy group, said it was shocked and disappointed. They warned that this ruling reverses 20 years. How gender law has worked in the UK, they fear it will push trans people further into the margins. Ellie Gomersall, a trans woman and politician in the Scottish Green Party, said the ruling undermines her dignity and identity. She called on Parliament to rewrite the law to make gender recognition fully equal again. So now, there are two powerful, emotional, and deeply personal worldviews. One rooted in biological certainty, the other rooted in lived experience. Can they both be protected by law, or must one yield to the other? Religion has long shaped how societies understand gender, identity, and roles in public and private life. Many traditional faiths define men and women based on biological sex assigned at birth. In Christianity, the Bible references creation in Genesis. Male and female, he created them. Theologically, many Christian denominations hold that sex is immutable and divinely ordained. Some interpret this to mean that changing one's gender identity goes against divine intent. Others, however, emphasize compassion, inclusion, personal dignity, arguing that loving one's neighbor requires acknowledging their lived identity. In Islam, traditional jurisprudence also roots gender in biological sex. Classical Islamic law assigns roles and responsibilities to men and women in family, inheritance, and worship contexts. Yet scholars today are increasingly debating how Islamic ethics should respond to transgender realities in a modern world. Judaism contains a range of views. Orthodox Judaism typically defines gender biologically, while Reform and conservative movements are more accepting of trans identities. The Talmud contains texts acknowledging complex gender categories beyond male and female, indicating that the conversation is not entirely new. Eastern religions offer additional insight. In Hinduism, gender is seen not only as physical, but as spiritual. The concept of Ardhanarishvar, half male, half female, embodies divine duality. In Buddhism, the emphasis is on transcending attachment to identity altogether. Gender becomes less about permanence and more about how suffering can be alleviated. So what role should religious teachings play in shaping modern law? Should secular courts be influenced by Scripture? Or should they base rulings solely on civil rights and scientific understanding? In a multicultural society like the UK, where religious belief is protected by law, this becomes a sensitive balance. Courts must uphold equality without endorsing any one faith's view. But believers also expect that the state will not compel them to affirm beliefs they do not share. That tension lies at the heart of many modern identity debates. To truly understand the legal debate, we must turn to science. What is biological sex? And how does it differ from gender identity? Biological sex is typically determined by chromosomes. Most people are born with either 20 chromosomes, which correspond to female, or XY chromosomes, which correspond to male. These chromosomes influence the development of reproductive anatomy, hormone levels, and secondary sex characteristics. This is referred to as binary biological sex. However, biology is not always binary. There are intersex individuals, people born with atypical chromosomal, gonadal, or anatomical sex characteristics. This can include conditions such as androgen insensitivity syndrome, Klinefelter syndrome, and congenital adrenal hyperplasia. Intersex people represent about 1.7% of the population, roughly the same percentage as redheads. They show us that even biology exists on a spectrum. But gender identity is not the same as biological sex. Gender identity refers to how a person perceives themselves. It's a deeply felt sense of being male, female, both, or neither. This identity is shaped by a combination of biological, psychological, and social factors. According to the American Psychological Association, gender identity usually develops by age 3 and is difficult to change. Transgender people experience a mismatch between their gender identity and their biological sex. This can lead to gender dysphoria, clinically recognized condition of psychological distress. Medical organizations around the world support gender-affirming care. This can include counseling, hormone therapy, and sometimes surgery. Studies show that when trans people receive supportive care, their mental health improves. Rates of depression and suicidal ideation drop significantly. So what happens when law, biology, and identity collide? Should the law prioritize chromosomal sex or lived experience? Should a transgender woman be recognized legally as female if her biology does not match her gender identity? The scientific community does not agree on all answers. Some biologists emphasize the binary nature of reproductive systems. Others argue that gender is a complex neurobiological process involving brain structure and hormone exposure in the womb. But the law must decide. And courts like the UK Supreme Court have begun to anchor legal definitions in biological sex, regardless of how science continues to evolve. Is that wise? Or does it freeze the law in outdated models? I must ask. Should law follow biology? Should law follow identity? Or should it adapt to evolving scientific understanding? Like, share, comment, and subscribe to Breaking Bulletin for more.